Members, we have reached the appointed time, and a quorum has been formed. I'll now call to order the meeting of the Bills Committee on Electoral Legislation, Miscellaneous Amendments, Bill 2015. Well, this is the first meeting for the substantive discussions. For this meeting, we have Mr. Lau Kong-wah, Under Secretary, Mr. Gordon Leung, the Deputy Secretary, and Ms. Chung Chi-ching, PAS, Mr. Lee Pak-hong, and Ms. Ma from REO, and Mr. Mo, Deputy Law Draftsman from the DOJ, and Ms. Wong, Senior Government Counsel, in attendance. Today we're going to have a discussion on this bill. So I'll hand over the floor to the Undersecretary for a brief introduction of the bill, and then members may wish to raise questions and we can have a discussion. Undersecretary, this is the Electoral Legislation Miscellaneous Amendments Bill 2015, which is about certain technical amendments for the 2016 electoral elections. In particular, we are going to change the names of some functional constituencies and some other technical amendments relating to counting procedures. In March, at the meeting of the CA panel, we gave an introduction to panel members. And in particular, we have a proposal to change the nomenclature of the Architectural Surveying and Planning FC so that we can add landscape architects or the landscape sector in the name. We'd like to have this bill passed so that we can implement the amendments as soon as possible. We have Mr. Christopher Chung, Mr. Tony Chia, Mr. Yip Kin Yun, who would like to speak. 7 minutes, Mr. Chung. Thank you, Chairman. A question for the Undersecretary. You want to change the nomenclature or names of the FCs, and also for certain sectors, you want to change the corporate voting system, and also for the Architectural Surveying and Planning FC, you want to add in the name the word landscape. So what are the criteria for making such changes? And in paragraph 6 of the paper, it says the Hong Kong Recording Industry Alliance Limited have convened meetings, and they want to be included in the Sports, Performing Arts, Culture and Publication FC. On what basis is this allowed by the government? I would defer the second question to my colleague. As for the change in the name of the Architectural Surveying and Planning FC, and that we propose to add the word landscape in the name of the FC. Well, the electoral base will not be changed. Landscape architects are always constituents in that FC. So no change to the electoral base, and the change in name would reflect that this is an FC for those sectors. And that's why we allow the change in the name of this FC. The second question. I would like to take the second question of Mr. Chung, and that is the Hong Kong recording industry Alliance Limited, asking to be allowed to join this FC. We have checked this particular industry, and this is an organization on IR. It's very much like the IFPI. IFPI is already an organization covered by the Sports, Performing Arts, Culture and Publication FC, and their members can vote in this FC, in the FC election. So we have accepted this application from the Hong Kong Recording Industry Alliance Limited. Mr. Chung, so you are saying that the electoral base would not be changed. It's just add the name landscape in the name. So in my case, can I ask the word fashion be added to the name of my FC, provided that there's no change in the electoral base? According to Ms. Chung, in the cultural sector, they think some organizations apply to be included because they think they should be part of the FC. Last time in the CA panel meeting, I asked the secretary about this question. There's an organization in my sector which has been asking for the same for 4 years. They never received any reply, and I've asked questions on 3 occasions. So far, the Bureau has not given any definitive answer whether that particular organization should be allowed to join the FC, to be part of the FC. So why is this Recording Industry Alliance Limited allowed to do this, but the one in my sector has not even received a reply? I would like to defer to my colleague, Mr. Gordon Leung, for the second question. As for the first question, the one on the change of the name of FC, in the CA panel meeting, some questions were raised. Well, actually, these sectors, these professionals are the license or they have a system of registration for members. So it's more straightforward to allow for the change of the name to include the word landscape. As for the second question involved in the textile sector, I will defer to my colleague. Mrs. Jones says that there was a suggestion from him saying that certain organizations should be included into the textile FC.
We gained some understanding of the situation some time ago, and we made a straightforward response some time ago. Mr. Chung had said that at this stage, or we have said to Mr. Chung that we do not propose to add that into the textiles constituency. We have received requests from other organizations or groups, and usually after large-scale review, we will make a response to all organizations which had written to us before. Mr. Chung, that's easy. Oh, okay. Let me wait for my second round. The time limit should be 7 minutes for each. I guess the timer is not quite correct. Okay, let me ask Mr. Leung. Just now I asked for the criteria. Now, for the cultural constituency, well, you said yes to the audio alliance or recording industry alliance, but then I have made this request for 4 years and I haven't received any response. Last time, I don't know whether it was you who responded, Permanent Secretary. There was a lack of certain information. Deputy Secretary, we do have the information. So to answer Mr. Chung's question, for all the recommendations we've received, according to our usual practice, we will invite the relevant bureaus to give us comments. And then, based on the information and response we receive, we will consider further. I would like to emphasize a point. This time, in our work, we try not to change the existing functional constituencies basis. That's our starting point. So, for this amendment bill, all the amendments are basically technical in nature. So, in all our requests and proposals, we try our best not to affect the existing definition of FCs. Okay, please wait for your second round. Right, he hasn't answered me really. I will wait for my next turn. Mr. Chair Wai Chun. Thank you, Chairman. About this bill, the amendments are technical in nature. I, in principle, support these amendments. The FC that I represent is named Architecture, Surveying, and Town Planning. Now, all along, there are 4 professions involved: architects, surveyors, planners, and landscape architects. And this reflects the constituency I represent, but then there's no landscape architects being included. Now, if you read this bill, in 20K, you can see that all 4 professional institutes are more or less the same. They do have registration ordinance. There are rules as to who can be electors. So according to the prospectus of the institutes, well, they will vote in their institutes, and these people must have the right to vote. I welcome the technical amendment by the government because this can better reflect the professional constitution of the constituency I represent, because all 4 professions are the same. In terms of the eligibility of their members, there are strict criteria, and all the members have attained more or less the same academic requirements. In order to express the point more clearly, I think the technical amendment of the name doesn't affect other things. I think that it is even more appropriate. It can reflect more correctly the 4 professions and the members of the institutes that I represent. So I must say to the government that we support the government's acceptance of our suggestion. In fact, I have consulted the 4 professional institutes on the name change. And basically, they are of the view that if you do not reflect landscape architects, it's not fair. So there is no objection to this amendment, basically. Chairman, this is the point I would like to make. Okay, thank you. Mr. Yip Kin Yun and then Mr. Mok Nai Kwong. In this bill, concerning the Education FC, concerning the description, I think there are different interpretations in different educational institutions. As a result, if election right will be such that in certain institution, people in a certain on a certain rank will have the right, but not in other institutions. Now the name list is being submitted by the institutions. If I am wrong, please correct me. If that's the case, if you read clause 4, 1AA, organizations in line with this description, those who are full-time working those who are full-time engaged in teaching or research and administrative staff of equivalent rank. Now these academic staff and teaching staff, well, how do we define academic and teaching staff? In the past, we received complaints. Now, let's say in some institutions, the lecturers, the associate lecturers, their research assistants, if they are full-time, then from the educational institute's point of view, they cannot be regarded as in compliance with this description, and so their rights will be removed. And when it comes to administrative staff of equivalent rank, what does that mean? If we talk about teaching and academic staff reaching the level of lecturer, associate lecturer, assistant professor, and so on, then they may cover some junior level. When administrative staff members get voting rights, they are usually more senior executives. So I think this wording is rather vague. Different institutions can interpret differently. We are talking about a very important matter, that is electoral rights. I think this is problematic. Can we have a clear list when we refer to full-time academic staff engaged in teaching or research? Which ranks do we mean in each institution? And what about administrative staff of equivalent rank? Can these all be listed out? If so, then we can compare the lists and see whether there are differences. So I think this will be very helpful for us to clear the name list. I don't know whether such lists are available now. If not, then can such name lists be prepared? I think it should be. It should even be included as a schedule. Under Secretary, Chairman, later on Ms. Chung can supplement. Now, for the name lists being submitted, now under the law, we rely on the educational institutes to actively produce or provide us with the name lists. And even if the name lists are available, we may not be able to really compare the lists. But I will defer to Ms. Chung to elaborate. Yes, PAS, please. Thank you, Chairman. In March, in the panel meeting, we said that we rely on the educational institutions to submit the relevant information to the EAC, and they will see which teaching staff can meet such description. After providing the information, then the EAC can work on elector registration work. Now, for these educational institutions, there are a lot of different ranks and positions, and I think the information will be provided according to the circumstances of each institution. And at the end of the day, there is a claim procedure. If a certain staff member is not satisfied, he or she may think that he is not included even after submitting the information, then he can make a claim according to the established channel. Then we will also take actions according to the established channel. Mr. Lee, anything to add? As Ms. Chung just said, in the elector registration process, according to the law, the universities will have to submit to us the teaching staff or equivalent staff, equivalent administrative staff So far, we do not have the information on which positions will meet the criteria because different universities have different establishment structure. And to a certain extent, the organizations, the institutions themselves will have to compile such a name list to confirm which employees can meet this description of full-time academic staff engaged in teaching or research and administrative staff of equivalent rank. In the past, we received this kind of inquiries, and we will consult the relevant institutions as to why a certain rank is not included and why a certain rank is included. If we're in doubt, we will consult the Bureau and the DOJ to see whether there is anything incompatible with the law. Because the establishment of these institutions is very complicated, there are many ranks and positions. We rely on information from the institutions to confirm. In the past, there were not many of these examples. The most obvious case was in 2011 when some institutions doubted about their subsidiary institutions and community colleges and see whether certain teaching staff members are eligible. And there are clarifications made already. In this amendment bill, the content is not amended, right? Only the reference is amended. Undersecretary, can you confirm this point? Or Deputy Secretary? Yes, you're correct. We haven't changed the actual substance. In the past, you listed out all the educational institutions' name. Now the amendment is that the UGC, well, things will be done through UGC, right? Yes. Okay, your time is up. You have to wait for your next round. Mr. Mok Nai Kwong and then Mr. Leung Yu Chung. Chairman, almost 1 year ago, well, there were requirements or requests from 9 organizations. Some are within the ITFC. So there may be changes in relation to members' eligibility, and there are a number of new organizations. So I have to check with the government to see why only one organization is accepted to be included. Last time, at the CA panel meeting, Mr. Lau Kong-wah told us that the mechanism is that the Commerce and Economic Development Bureau should be consulted, and but then in the process, these organizations are not contacted. Even the organization that has been included had not been consulted, and I was not consulted, even after I have sent in a letter. And only at a very late stage, when everything is ready, you consulted the panel. Now the panel doesn't have enough time to ask you. And now we are trying to ask you rounds and rounds of questions. I want to say to Chairman that this mechanism is not desirable. It is purely black box operation. The government is not accountable to the industry and members. Okay, let me go through these organizations one by one. Mr. Chung Kwok-ben, well, there are a number of organizations which put in requests in 2007. If you read the minutes of the CA panel meeting and also similar bills committee meetings, now I'm not referring to the newly added ones. Some organizations have been requesting an amendment for 7, 8, or 10 years, but no one had listened. Okay, first of all, the Institute of Engineers.
And IT's division, they've asked through me that if you look at the legislation, 22 set, section 22 set, bracket 1, bracket B, on fellows members and graduate members of that division. It's in the open domain. There are fellows, members, associate members, and graduate members. Simply put, there are four different ranks. 1, 2, 4 are able to vote, but not number 3. That's why the Institute has asked me to ask whether the one in the middle, graduate members are allowed to vote, but not associate members. The same has happened to the engineering FC. What happened then? Why this particular group is not covered? Maybe if we change this, we have to change the same for the engineering FC. Undersecretary, as Mr. Mok has said, the same point was raised in the CA panel meeting. I have to stress that this is an established procedure. It has been applying to different FCs, so we are not doing anything special for any particular FC. Whether we accept or not accept certain organizations as constituents of an FC, the basic principle is to look at the organization to see if it's representative, and we'll consult the relevant policy bureau. The relevant policy bureau is in communication with these organizations. The CMAB is in no position to maintain communication with all these organizations, so we need the assistance of the Policy Bureau concerned for assistance. I hope Mr. Mok will understand this. So as for the proposals made by members with regard to the qualification of certain organizations, some of them are accepted, some of them are not. Can you respond specifically to this institute and the members? If not now, perhaps in writing later? Well, according to our usual practice, we do not put forth reasons for cases which are not accepted. But I have already set out the principles. Chairman, this is outrageous. I have other organizations which I would like to talk about. I hope the Chairman will allow me to do this. All right, if you say that you don't want to accept new organizations, but still for an existing institute, you have something as strange as this. This institute has 4 categories of members, A, B, C, D. A, B, D are allowed to vote, but not C. But you are not saying that you are unable to comment. I think I used to think that this is somewhat rather mysterious, something that happened in a black box. Well, I have to queue up again. I want to ask questions about other organizations. Mr. Leung Yu Chung. I note that some names have been changed. In particular, some trade unions for container truck drivers, their name now contains the word logistics. Has their situation been confirmed by the registrar of trade unions, and has the information been gazetted? The registrar of trade unions will from time to time ascertain whether the unions are still active. Some unions are already inactive, and the registrar would urge them to submit relevant documentations. But some of them have not been delisted so far by the registrar. My question is, will these trade unions still be included in the list of constituents? Are you going to communicate more closely with the registrar so that the inactive ones should be or can be delisted? Mr. Lee, I think Mr. Leung Yu-chung is referring to trade unions covered by the Labour FC. Trade unions must be registered, and they must have employees as voting members, and they must be active during the relevant period to be qualified. During the checking process, we ask the relevant unions, relevant organizations to submit documentations to prove that they are qualified. If they are not active, well, I don't know what that means exactly. Maybe they don't have a lot of activities, but if they are still registered as trade unions, they are qualified. If they are not registered as trade unions, of course, their registration as voters will be, as electors, will be cancelled. Of course, we are talking about registered trade unions before they are qualified as electors, so they're sort of perpetually there. How can you verify that they are in operation or active? How can you confirm this? Do you have a mechanism to check whether the trade unions are active? Chairman, I think I have to repeat the electoral legislation. First of all, the unions must be registered as trade unions, and then 12 months before the application is submitted, they should be active in the preceding 12-month period. So that's at the point of submitting the application. And then subsequently, annually, we would check whether the unions are registered with the registrar of trade unions. This is done annually. As regards whether the trade unions are active continually after registration, there's no requirement on this. So we'll check if the trade union concerned is still registered with the registrar. If that's the case, then the qualification as a voter will be kept. Registration doesn't mean that it's active. Sometimes it's just register, nominally register. It exists in the list of the registrar of trade union. If you think that if it's as long as it's registered, it's active, then it's not really the case. According to the law, at the point of registration, the union must be active in the preceding 12-month period. But then subsequently, there's no requirement that the REO should check that the trade union is still active subsequently. So are you suggesting that they should take one more step? If that's the case, then a lot of other things will be involved. Well, the registrar of trade unions does check if trade unions are active, and they would also ask documentations to be submitted. But if the unions are not active, they do not submit any records or documentations required by the registrar. It's just like the checking procedure for the voters in the GC election or DC election. You cannot say that as long as it's registered with the registrar is active. You have to check it according to the law after registration as a voter. If the union continues its registration with the registrar, then according to the law, its qualification as a voter continues. But there are other requirements under CAP 332. If certain requirements under the trade union ordinance have to be submitted, and if they fail to comply, then after some time the registration will be cancelled by the registrar. Chairman, I know that some trade unions keep dragging their feet, and the registrar allows them to procrastinate. So these are just trade unions that exist in name only. So are you going to be more stringent in the future about these unions? Can you do something about CAP 332? Legal advisor? According to CAP 332, there's no requirement that a trade union must conduct some activity during any period, but a trade union, a registered trade union, has to submit the annual returns to the registrar. And such records and documents can be checked in the office of the registrar, and people can check the annual reports of these trade unions. And also for electoral election, and that is CAP 25, capital 2L. There's no requirement on whether certain activities must be carried out for trade union to be qualified as a electoral FC voter, and the maintenance of the qualification does not turn on any particular level of activity on the part of the trade union. Mr. Christopher Chung, I want to know, when did the Hong Kong Recording Industry Alliance Limited submitted its application to you for inclusion in the relevant FC, and how long did you take to approve it? I don't have the exact information on the date of submission of the application. If I remember correctly, this organization wrote to the Bureau at the end of 2013 or thereabout, and then there was a need to clarify certain things, and they had to carry out certain internal procedure.
So when we reported to the panel, we did not submit that recommendation for your scrutiny. In March, after the panel meeting, we gathered together all the relevant documents, and we have also received confirmation. So this time we have included that in. Mr. Chung, Chairman, in less than 2 years, this organization is turned into an eligible elector in their constituency. Now, the organization that I mentioned just now has been formed for 15 years, and they made application in 2010. So far, the government has not written to them at all. So far, there has not been a letter asking for supplementary information. Just now, the Undersecretary said that when they received an organization's application, they will check with the relevant policy bureaus. I'm sure the relevant bureau knows this organization. I do have some doubts whether the Bureau has checked with the relevant Bureau, i.e. the Commerce and Economic Development Bureau, because in the last government, Mr. Frederick Ma was invited to attend this trade association's event, and Mrs. Rita Lau has been invited to attend their events as well. And in this government in 2013, Mr. John Tsang, the financial secretary, attended this organization's events. So if your bureau had checked with the relevant policy bureau, I'm sure the bureau knows this trade association. But so far, not a letter has been sent to this organization for 4 years, and this is unacceptable. I asked several times, but there has not been any explanation. So, Chairman, can we give the Undersecretary an opportunity to explain? Who would respond? Deputy Secretary. Chairman, I won't have much to add because we explained just now that when we receive any organization's request to join a certain FC, we will consult the relevant bureau and then make a decision. In the past, when we wrote a reply letter to the applying organizations, now usually when we receive the letters, we would make preliminary reply. As for decision, usually after a large-scale review, we will send out reply letters at one go. This time, if this amendment exercise is finished, then in the past, we received letters from different organizations, and we will make a response at one go. Well, I'm sure Mr. Chung will continue to follow up. Even after listening to your answer, you know that there is this trade association. However, you would not explain to them one by one why certain organization is accepted and why not the others. 15 years have passed, but then for the Hong Kong Recording Industry Alliance Limited, it has taken 2 years for them to be included. So can you offer some reasons or some explanation? Perhaps this is not the right occasion, but at least you should give a direct explanation to the relevant trade association. Will you do that? Deputy Secretary, Chairman, usually we will not explain things in detail to each and every organization as to why a certain organization is included but not the others. This time, our precondition is that on the basis of existing FCs, so existing FCs won't be changed, and then we will make technical amendments on top of that. Our view is, unless if the amendment itself is purely technical in nature and it won't affect the definition of the electoral base, otherwise we are inclined not to make the change. Just now, Mr. Mok, Mr. Chong referred to some organizations they know. They had written to our bureau, and then we consulted other government departments after that. There are some other trade associations and organizations that you haven't mentioned which had written to us, and we treated them in the same way. Mr. Chong, thank you, Chairman, for following up things for me. You asked in a very good way. The Deputy Secretary always said that responses or replies will be made in one go. I don't want to hear that. So decisions are made at one go, and all the organizations are treated as one basket. Now, I'm not asking about your decision, but then not a response has been made. The Deputy Secretary said that a response had been made, but in the past 4 years, there has not been a letter replying to the organization as to whether they are eligible. This is not a matter of making decision at one go or treating organizations as a basket. There is no response, really. Mr. Ip Kin Yun and then Mr. Mok Nai Kwong. Chairman, I would like to follow up again on Clause 4 about the tertiary education sector. It refers to administrative staff of equivalent rank. Administrative staff of equivalent rank, well, my understanding is that it should be related to the full-time academic and academic staff engaged in teaching or research. So equivalent rank would refer to this. Now, in universities and tertiary institutions, there are not many academic staff. So apart from academic staff engaged in teaching or research, there are a large number of administrative and auxiliary staff. However, it is very difficult to differentiate between administrative and auxiliary staff. So if you refer to administrative staff of equivalent rank, let's say if all teaching and research staff members are included, then the scope of administrative staff of equivalent rank can be very big. So big that there will be substantial change in the nature of this sector because many people will be administrative staff. But if you only include a small number, based on my understanding, the existing rule is that only senior administrative staff are included. For example, deputy school heads or university heads, some of them had not taught before. They are responsible for finance. And then there may be the heads of the school affairs office. They do not teach, they do not do research, but then it is not right if they do not have the right to vote. So for these administrative staff, they are given the right to elect or to vote. But when it comes to equivalent rank, then, for example, the teaching staff and research staff, if they have to be in equivalent rank, then there are only very few teaching, academic, and research staff who can reach this rank. I don't know whether you understand me. For example, when we say administrative staff of equivalent rank, they should be on par with academic staff engaged in teaching or research. Now, for one category, we only consider senior executives. For the other category, from junior to senior, then this is not balanced. So when it comes to equivalent rank, let's say if there is any challenge from people, some will say that there are junior teaching and research staff members who have the right to vote, but then I am on the same grade, but I am an administrative staff. Why can't I have the right to vote? So there will be problems. Now, that's why I asked whether there's the need for a checklist. I think this name list is very important. I think that this name list exists already. In the past elections, I believe that when the institutions submitted name lists to the government, there's also a list based on ranks. And all the names are listed out before the list was submitted. So there should be the name list in the institutions. So I don't know whether the government can obtain the prepared name list from the institutions. Perhaps we can also ask whether they are going to amend the name list for the coming term. With the two pieces of information, we can look at the list from all institutions. Then we have to think of two things. Number one, we want to check whether there is difference in the institution's interpretation. And number two, when it comes to equivalent rank, we will have to examine in greater detail whether the academic staff and the administrative staff are really on equivalent rank. I think that the government should obtain a name list which is already in existence from the institutions, and the information can serve as reference materials for us. Deputy Undersecretary, Chairman, we can try to get some understanding about the name lists. And just now, Mr. Yu referred to comparison. Sometimes the name of position may be the same, but the nature may not be the same. If you really want such a name list, we can consider trying to obtain it. I don't know whether Mr. Lee has got that information in his file. Mr. Lee? Thank you, Chairman. EAC or election REO doesn't have this name list. Now, when it comes to equivalent rank, in our implementation, well, if I make any mistake, the DOJ colleagues can correct me. Equivalent rank refers to full-time academic staff. So Mr. Yip's understanding is correct. Equivalent rank means administrative staff of equivalent rank as the academic staff. And now in the law, there is no definition of academic staff, administrative staff, and equivalent rank. So discretion is given to the organizations to work according to the law to see which administrative staff members can be regarded as on equivalent rank. Even though there isn't a name list now, when various institutions submit a name list of eligible persons to the REO, they must have gone through this process. I don't know whether they have got this name list. I won't ask for it, but then they must go through a process to confirm which academic staff, teaching staff, or research staff and administrative staff are in line with the legal requirements. Because there are the relevant requirements under the Legislative Council Ordinance. But to put it simply, we do not have the name list on hand. And is it really useful to have that name list? We have to get the confirmation of the tertiary institutions on the eligibility. So far, there isn't such a requirement under the law. Mr. Yip? Now, in this amendment, this is not part of the amendments. So we are only referring to the principles, the subventions. A response has been made just now, so this part is not amended right now. You have identified some problem. I'm worried that there may be a problem. So has there been problem now? In the past, there were complaints. Okay, next, Mr. Mok Nai Kwong and then Mr. Chung Kwok Bun. Chairman, I don't know whether the Undersecretary has encountered difficulties. But when you make the decision on who can join, who will be included, who can't join, and so on, which can be amended, if you say that this cannot be changed, I really can't understand. You ask for our understanding, but then are we saying that we have to understand you with no explanation? Even if I understand you personally, now we are talking about a few thousand members of the organization I mentioned. I don't know whether they will find it understandable when it comes to whether or not they can get the voting rights. So for FCs and election committee, nomination committee, the government doesn't need to offer any explanation. It's easy to manipulate. In my FC, there are statistics from CNSD that there are 70,000 practitioners, and in 1 year of university, there are a few thousand graduates. And last time, in my FC registration, there are 6,000 odd, now 5,000 odd. Next year, there may be more, but then I think it's only 10% or less. Okay, for FCs. We have to have FCs, but then the representation must be reasonable. And we asked for amendments. You said no. You are not even willing to make explanation. Just now when Mr. Chung Pok Bun asked follow-up questions, you realize that some organizations make application. You will ask for supplementary information for the organizations I named. There has not been any contact. This can be put in record. No supplementary information has been asked for. You said that the bureaus are very familiar with these organizations. Yes, I know. Many of these organizations have got subventions on ICT event or award, ICT red wine festival, and so on. But you offered no explanation. If they check with CBD secretary, then he will say, okay, we are familiar with each other. Why is it that I am not allowed to join?
It seems that CMAB is passing the buck to the CEDB. You said that there were consultations, or you said there have been consultations with the policy bureaus all along. Can you give us information in respect of ITFC? That is in respect of CEDB. Can you give us some information or records? Undersecretary, I said I would like to ask for understanding in that the CMAB will not be able to know whether the certain organizations represented in the FCs are active or are representative. We have to rely on information provided by the policy bureaus concerned. I can assure the member that for these organizations concerned, we did consult the policy bureau, but you cannot tell us when it was done and also whether the records can be made available. Well, I think we should put on record that they refused to provide the information. I've quoted the example of Hong Kong Institute of Engineers, and the same provisions can be found in the two FCs, the IT FC and the Engineering FC. So instinct would tell us that the IT falls under the purview of CEDB, and engineering will of course fall under the purview of the Development Bureau. Did you consult the Development Bureau? I can confirm that in respect of those organizations, we did consult the relevant policy bureaus. So that would include Development Bureau? I don't know. They refuse to tell us. I think we can only put on the record that they say that they have consulted the relevant policy bureaus. They don't even tell us the policy bureaus concerned. Undersecretary, if you want to know which policy bureaus have been consulted, well, I can provide the information to Mr. Mock. Okay, thank you. Undersecretary, please provide the information to us. Then I will have a question about policy. And that is to say, your practice is that when you receive an application, well, you don't have an application form for organizations to use, so they will have to write to you, I suppose. And what is the policy guiding the decision-making process? Do you have any information for our reference? I think it would be important for other organizations whether they want to be part of the FC concern or for the nominating committee, elections. If there's such a policy, can you tell us when it was devised? Or has the policy been the same since the reunification? And what documents or legal papers would set out those criteria? And then organizations would know what the requirements are and how they can comply or satisfy the requirements. And you have to set out clearly that it's your policy not to disclose the reasons for rejecting certain applications for qualification as FC electors. As for the qualification to be accepted as FC electors, is in the law. Mr. Mok may wish to refer to those pieces of legislation. And for the past terms of FC elections, we have been using the same policy. No change has been made. We look at the representativeness and the qualifying factors and so on and so forth. Mr. Gordon Leung has said that whenever they have received an application, they would provide a response. If that's the case, can you give us a copy of your reply? Deputy Secretary, that will be okay. I have one with me. On the 27th of January 2012, we did provide a reply. I can provide a copy to Mr. Chung. You can do this after the meeting? Okay, Mr. Chung. What's the date again? 2012? 27th of January 2012. I was not a member of this FC at that time. But after I became one, I'd asked you 3 times for a reply. Why didn't you provide the same reply to me? I'll check the records. From what I've got here, on the 27th of January 2012, Mr. Chung wrote to us in the name of name of chairman of the clothing industry organization. I don't have all the letters with me, so I cannot recall the exact dates. But as I've said, if there's a request in the middle of a major review, we will certainly give an interim reply, and then after the review is completed, we'll provide more detailed reply as well. Mr. Chung, that's okay, Chairman. As the Deputy Secretary said, that they have conducted reviews. I have pursued the matter 3 times. I haven't received any reply. Perhaps you can give me copies of your replies. And the same question is still outstanding. Why didn't you give the replies as to me on the previous occasions? I'll provide the information to the member after the meeting. Mr. Yip Kyun-hin? Oh, yes? Ms. Sit-ho, you first. Ms. Sit-ho? It's okay for me. Oh, this is the arrangement that we have made. Recently, some psychologists have made representations to us. They were graduates from overseas institutions. Psychology did not originate in Hong Kong. We have reasons to believe that overseas graduates in psychology will not be inferior to those qualified locally. But for clinical psychologists, the local clinical psychologists, they have a local organization. If you want to be FC elector in the health services FC, you have to do this through this local organization representing local clinical psychologists. So those who are qualified overseas do not qualify to vote. Although we all know that FC should be scrapped as soon as possible, but before that happens, can we be giving some explanation about the differential treatment? Is this peculiar to this FC or this particular profession, or does it also happen with other FCs? Can someone who are familiar with this sector give us a reply why these overseas qualified psychologists are not eligible? I don't think we have sufficient information to provide a reply. First of all, I want them to understand the situation first. The health services FC is based on professions. Whether you work in the HA or you work in the government, you are qualified as professions. But since the voter registration is done through the local professional body, then as a result, those who are qualified overseas do not get the right to vote. I can provide some information to Ms. Ho. If we are talking about accountants, if you are a member of Hong Kong ICPA, of course, you are eligible to vote. But you are not, if you are not a member of a local accountancy body, if you are a member of, say, an Australian accountancy body, you are not qualified. But is this a case of local ICPA, HK ICPA will not accept overseas graduate members? I don't think that's the case with accountants. All right, if the local professional body accepts members who are qualified overseas, that's okay. But in the case of clinical psychologists, the local professional body do not accept those who qualify overseas as members. So they are not able to register as voters. I don't think Ms. Ho is asking for a big change in the electoral base. It's just a question about whether why a certain professional body and its members are not eligible. We'll check some information. According to Section 20I of the ordinance, clinical psychologists can register as voters in the FC. They must be employed by a public hospital of the HA, or they work in a hospital registered under the relevant ordinance, or the CUHK hospital, or Hong Kong U hospital, or other hospitals. So it's not related to professional body. I'll ask those who have made representation to us to list out their experience in writing, and then we'll ask the government to provide a response. Mr. Charles Mok and Mr. Yip. Mr. Yip first.
I would like to follow up on the previous point. Now, I said I refer to inclusion in the schedule. That may not be necessary because it is quite complicated. Educational institutions may create new positions and new ranks anytime. So this may not be a must, but this is an alternative. An important point is to clarify the relationship. For example, when it comes to full-time academic staff doing research and teaching work, what ranks are included? And what about administrative staff of equivalent rank? What exactly are the positions and ranks we're referring to? I hope the government can obtain from the educational institutions existing name lists if they have them, so the name list can serve as reference by us. Is this workable? I hope the government can give a positive reply. Undersecretary, we already said just now that we will try to do that. Okay. Mr. Mok Nai Kwong and then Mr. Chung Kwok Ban. Chairman, you also laugh. I would like to be recorded in the minutes the information of the 9 organizations. First, Institution of Engineers IT Division, and also Engineering Division of the Institute of Engineers. The eligibility criteria are the same. Senior member, associate members. I don't remember the Chinese name. Graduate members, junior members, associate members. The one which comes third are not included. Junior members or graduate members, they are included. I don't understand why. For the other 3 categories, there are 2,300 members. For associate members, there are 220. The second organization is IET Hong Kong, Institution of Engineering and Technology. Hong Kong chapter. The head office in the UK had once changed the name and eligibility of the members. As a result, some members who have voting rights can no longer be included as members. They cannot be registered as members anymore. So these are non-chartered engineers. In terms of eligibility, they are definitely qualified if we refer to other similar organizations. There are now 3,000 members who can be registered. Not all of them have registered. Some may have gone to the engineering FC. And 1,400 non-chartered members have not been included. The third organization is very similar to the 2 other organizations. Under the ordinance 20C, bracket 1JA, there are 2 organizations there. In my paper to the Bureau earlier, I mentioned the Security Guard Association. There is another organization which had not made final decision, but they are in more or less the same position. PISA and International Information, ISACA, Hong Kong, China chapter. For these 2 organizations, people have to take examinations. And in order to be eligible, they have to have at least 3 to 4 years work experience. But now under the ordinance, after getting the professional qualification, they have to wait 4 more years. And their request is to change this 4-year requirement into work experience. So they don't need to wait 4 more years after passing the examination. Now, we are familiar with other organizations like Hong Kong Computer Society, Internet Professional Association. The requirements are not the same. For those with 4 years working experience and the related degree, they are eligible already. Now, these 4 organizations are already in the FC, but they do want some amendments. Let me give you some numbers. For PISA, they don't have many members. The number of newly added members that may be affected by this change may only number 100 odd. Now, there are 5 organizations that I would like to go through very fast. I don't have the Chinese name, Information Security and Forensic Association. So you have proposed to add this time. I support this proposal. For the other organizations, they include, well, among these organizations, 2 are personal organizations. In our FC, there are both corporate votes and individual votes. Information Security and Forensic Society, well, they are on individual basis. There is another organization also on individual basis. They have been formed in Hong Kong for 30-odd years. Government, IT, Government Information Technology Professionals Association, they have around 700 members. All of them work in the government. They are IT people. They are definitely qualified. You know who they are exactly. So I think we should have confidence in these people. However, this time, well, I think the Bureau is familiar with these people because they work under the Bureau, almost all of them. But they have not been consulted, no explanation has been offered. You just said that they can't join, they can't be included. And then there are 4 other organizations which are trade associations. IT Service Management Forum, Hong Kong chapter. This is an international trade association, the Hong Kong chapter of it. There are 165 corporate members. And then Hong Kong Retail Technology Trade Association, there are around 100 corporate members. The other is Hong Kong Computer Association or Trade Association. They have around 200 corporate members. And then Hong Kong Electronic Industry Trade Association, they have around only 60 to 70 corporate members. Okay, Chairman, for these organizations or associations, according to this proposal, the government has not given explanation. The government has not consulted them, with the exception of the Commerce and Economic Development Bureau. However, they cannot tell us the correspondence between CMAB and CDB. CDB should be very familiar with these organizations, but it is surprising that these organizations still have not been included. Okay, my time is up. I would like to take this chance to ask one last question. In this Bills Committee, do you think that we can invite deputations to attend a hearing so that they can voice their requests? I think other sectors may find this necessary, Chairman. Last time in our last meeting, we have already fixed a date of 9th of June, 2:30 to 4:30. That is the time for hearing. So you can invite relevant people from your sector to come. Mr. Chung Kwok Bun. Thank you, Chairman. Chairman, you haven't expected that this bill will be so complicated. We have been asking questions for almost 2 hours. Questions are only about 2 sectors. Mr. Leung Yiu-chung just asked a question about having registered but have not operated. Now, in my sector, some companies are registered at a certain address, but when I visited them, it has turned into a football training school. So I want to know how the government will deal with this. For example, well, if they have moved, then they should have changed their address. But if they have no operation, the premises may be rented out, then how should this be dealt with? Who will take the question? Mr. Lee? Chairman. Now, under the electoral legislation, I think basically there are 2 different categories. Some may be registered and some may be licensed. Mr. Lee, can you speak into the microphone? Thank you. There is another category which are members of formed societies or organizations. Now, when a member joins an organization, then of course he or she must be eligible. We will check whether that organization is still in existence. That means whether there is a registration in place and whether that organization holds a business registration. Is it still valid? Is it still in existence? If that organization continues to hold a registration or a valid license, then there is another category. If it is a member of a constituent organization, if it is a valid member, then it will the registration is eligible. Then what about address? Address is not a relevant information in FC registration. When we have to contact a certain organization, we need an address. Every year, when necessary, the correspondence address, like telephone number and also correspondence address of the office will be provided for us. Mr. Leung Yiu-chung just said, yes, there is a registration, but no one is using that premises. It seems that the Bureau do not have a follow-up mechanism to deal with this. So there is no more operation, or the premises is being rented out to another organization. So is that still a valid voter or elector? This is in doubt. Mr. Lee, any supplement? When REO does voter registration, we will refer to the legal requirements. If he still meets legal requirements, then his eligibility as voter can be maintained. Any follow-up? Chairman, I have a technical question to follow up on. Some trade associations and institutions, for example, are considering their members' eligibility. Let's not talk about members' eligibility, which is more complicated, because after this bill is passed, there may be amendments. Okay, if it is because of their own internal affairs, if this bill is passed, next time when they have election again earlier than 2016, and if there are things not compatible with this bill, then what will be done? You cannot say that no amendment is allowed because of this bill. And some organizations have discussed, but not a decision has been made, because sometimes the name of the organization may be changed from time to time. And, well, perhaps today they do not have enough time to change the name, or they have not decided yet. From now till the next election, the name of the organization may be changed. Then how will the government deal with this matter? Mr. Lee? You are clear of the question? Right. I know what Mr. Mok is asking about. After the bill is passed, the bill will amend existing ordinance. Then, according to the amendments, we will deal with the eligibility of all related voters. In the past, after the bill is passed, if there are circumstances that some members' eligibility, some voters' eligibility becomes problematic, we will act in accordance with the prevailing law. Now, the question is simple. Okay, if the bill is passed, but then before election, can the organization change its name? Now, does Mr. Lee mean that it is best not to change the name, otherwise things will be confusing? You will enforce the law word for word, and then if the organization changes registered name or members' eligibility, then the members' right to vote may become problematic.
Because you follow the existing law. If that's the case, you should tell them. You should tell all these organizations, because it could happen without their knowing it. Many associations are not set up for the purpose of participating in elections. Mr. Lee, I wonder if our colleague from the DOJ can also offer some explanation. In enforcing the law, we look at the legislative requirements. We also look at the policy. If it's just a change of name, we have some technical amendments because the name has the word limited in it. If we disqualify the relevant body because of the change of the name is of such a nature, then I think we shouldn't do it. We have to look at the legislative intent as well. But I wonder if our DOJ colleague can also supplement. Mr. Mo. The provisions on FC members, usually we talk about the constituency is composed of certain people or certain bodies. It's usually in the form of a list, and there will be some description there. This is drafted in accordance with the policy direction, but how is going to be operated? I cannot reply on behalf of a policy bureau. So from what I heard, if it's a minor amendment, if the word limited is added, then it would be okay. Say if it's instead of ABC, it's changed to the name of XYZ. But in terms of registration, the articles of association, and so on and so forth, there's been no major change, and we all know that it's the same body. So maybe you can adopt a more relaxed approach so that eligibility or qualification will not be affected.
資格上邊嘅修訂，本來譬如話3年經驗就變咗5年，或者
If they change the membership qualification criteria, say instead of 3 years of experience, it now require 5, or vice versa, then there may be more complicated. So I think you should inform these bodies that if they change things like this, then their eligibility as an FC voter will be affected. Mr. Lee, I think Mr. Lee, I think Mr. Moore will understand that I cannot respond to questions on individual cases. If we encounter such a case, we certainly seek advice from the DOJ. I've been talking about some technical amendments, for example, the addition of the word limited. There's a policy intent for every piece of legislation. If they have the same members, and the name is just different by the word, for the addition of the word limited, we cannot just cancel or disqualify the body. But Mr. Moore is also asking another more complicated question. For example, if the criteria for membership is changed, say instead of 3 years of experience, it's now 4 years. But when these constituent organizations admit members, they have to act in accordance with their articles or memorandum. And they were talking about membership criteria, voting criteria, and also their object and the object of the organization, and a change to the object may require consent from the bureau secretary. So these bodies will certainly pay attention to such changes. I think Mr. Lee and Mr. Moore are both correct. But you are talking about that in some cases, when the bodies that can be registered as FC voters, the provision may adopt a descriptive approach. So Mr. Lee and Mr. Mo's answers are both valid. But Mr. Mo, if a particular body is named. For example, for education FC, instead of naming the 8 tertiary institutions, now it's a description. So instead of naming the names, so if the approach is listing the names, then a change in the name would cause problems. Mr. Christopher Chung, Chairman, you said the public hearing will be held on the 9th. Can we invite representatives from other bureaus to attend? Because the Undersecretary has said time and again that for certain matters, they have consulted the relevant policy bureaus. So I think the deputations in the public hearing may want to put questions to the relevant policy bureaus and try to get some response. I think a public hearing is held for the benefit of deputations to express their views. But if we want to discuss policy matters with policy bureaus, that should not be done during the public hearing. I think in our Bills Committee meetings, we can do it. Because in the public hearing, we give time to deputations to express their views. So if some deputations put some questions to the government and there are no policy bureaus there to answer the questions, then we can invite the relevant bureaus to attend the next Bills Committee meeting so that they can provide answers. Well, actually, I believe the bureau, the CMAB, will be represented, and they will be able to answer some of the queries. Undersecretary, well, of course, it's up to you, Chairman, to make the necessary arrangement. Let me stress again, for every FC, every sector or organization seeking to be accepted as FC voters, we will not comment on individual cases. According to the legal advisor, we have been given to understand that certain things may happen in certain situations. Well, in my constituency, we have names and also titles, fellows, senior members, and so on and so forth. And sometimes there are revisions to the membership criteria. So instead of 5 years of experience, it may be lower to 3 years, or it may be the other way around. There are typical revisions to the criterion of experience. So that may affect the seniority of the membership. But from what I've heard, the government has given a very specific or rather extraordinary answer. You have to consult a bureau, or you have to get the consent or approval from a bureau for changes. I don't think they have to seek an approval. So some of the changes have happened, and sometimes the decision was taken out of Hong Kong because the body was just a Hong Kong chapter of a bigger organization. And I may have misheard you. This something is rather peculiar. The association is there for some professional reasons or for research. Do they have to consult you for changes? In the worst case scenario, if they make changes without letting you know beforehand, would voter qualification be cancelled? they would ask you, because they do mind that they should continue to be qualified. Otherwise, there's no need to ask you. P.S. Let me respond to Mr. Charles Mock's question. It's actually in Section 3. There's a 2 capital A. If these constituent organizations have changed certain things in the articles or memorandum in 3 aspects, for example, the object, the membership criteria or eligibility, or the voting rights of these memberships in the general meetings. If there is any change to these 3 issues, they will require approval from the Bureau Secretary. But the approval from the Bureau Secretary is only sought for the purpose of confirming the eligibility or the qualification of the body as an FC voter. Of course, they don't have to consult any Bureau Secretary if they make changes for their own purposes. But if they make changes that will affect voters' registration, then they will have to do it. Well, the relevant bodies would be most reluctant to violate the law. The body may be just a Hong Kong chapter of a bigger organization, and they don't have a say. Or even for a local body, they may think that they don't mind doing something that may affect their FC voter eligibility, and they do not get your written consent beforehand. Is it that they have violated Section 3 of the law you have referred to? Is the worst penalty going to be disqualification from the FC election? Or would they be committing another offense under another law? If we change the membership qualification period from 3 years to 4 years to 3 years, you may think that it makes a difference as regards whether the members should continue to be able to be electors. I was referring to the Electoral ordinance. We would remind the constituent bodies of this requirement. When they are accepted as constituent bodies, well, they should know the requirement, because we will set out which members are eligible as electors. If without any approval from the Bureau Secretary and they make changes, then I don't think that's a question of misunderstanding. When we seek information from them, they always act cautiously as regards which members are eligible. And we also ask them whether they have changed any rules regarding membership. We have shown concern in the case of certain bodies. I won't name names. We have reminded them that if they want to make changes to membership admission, they will have to seek approval from the Bureau Secretary concerned.
Mr. Chung Guoban. Now, there are 2 organizations, and these 2 trade associations have more than 25 years of history in the textile industry. In our FC, from reunification till now, in the past 18 years, there are voters in the textile FC, and 2 to 3 weeks ago, they received a letter from the government saying that they do not belong to this FC. They should consider moving to Industry 1 or Import-Export FC. I really find this not understandable. Why is there such a stupid move? Now, after reunification, these two trade associations have been in our FC for 18 years, and 2 weeks ago, they were told that they did not belong to this FC. I want an explanation from the government. Who can answer? Under Secretary, Chairman, I do not have the information with me now. We can go back to do a check. Mr. Lee? Chairman, I understand Mr. Chong's question. Looking at the textile and garment manufacturing FC, there are two types of organizations which are eligible to be registered. One, those who have the right to vote at the Hong Kong Textile Industry Alliance or Federation. And then there are 12 organizations that are eligible to be registered. So the law is very clear. That is, concerning the Textile Council of Hong Kong Limited, if the members belong to these 12 listed organizations, then they cannot personally register themselves as members because they are constituent organizations. Now, when it comes to FC, REO doesn't set out these requirements. This is related to legislative intent. Now, any constituent organization itself cannot become a voter. Their members can become voters according to eligibility criteria. Now, under the Textile Council of Hong Kong Limited, there are 12 corporate members, so that means these 12 will not be. But then 2 of them received the letter. So 2 out of these 12 have received such a letter, right? Yes. So why is it that over the past 18 years, the government did not make this point, and then all of a sudden, 2-3 weeks ago, you have made this point? We will go back to look into this case. Perhaps you can pass on the information to the Bureau for more understanding. Members, any other questions? Mr. Mok Nai Kwong? I would like to continue to follow up on written permission under number 3. I understand that in the past there were not many problems in terms of operation. And there is this approach in the past. When that law was made, I was not there. My feeling is strange. When organizations join the FC, theoretically speaking, some operational freedom or autonomy is being handed over to the government. So let's say my organization wants to change name or change members' eligibility criteria. I have to get the government's approval for the sake of joining the FC. I think this is a matter of principle. There may be the operational need for the FC, but then as the operator of an organization is like surrendering part of your autonomy to somebody else. Well, I want to change things, but I don't want to ask you for permission. You want us to seek your approval in advance. I think this is infringement of autonomy. This is just my personal feeling, but then the organizations have not made this point. Well, if I really make these changes, then next time you will deprive this organization of its voting rights. But then it seems that you are asking this organization to surrender its autonomy. Okay, this is just my opinion. It is not part of this meeting's discussion. Now, a certain organization, Hong Kong Remote Medical Association, IT Division. J, Remote Medical Association, ordinary members' voting rights is being cancelled. Can you tell us why? Okay, I think we can discuss this when we are on clause-by-clause examination. Who can take this question? Yes, thank you, Chairman. To answer Mr. Mok's question, regarding this Remote Medical Association, they wrote us a letter notifying us that they had already suspended operation. And in our legislative amendment exercise, we will delete some organizations that had ceased operation. So since they have notified us, we have included them in the amendment. Okay, Chairman, if one organization has ceased operation, but then it has not been so responsible to notify the government accordingly. Of course, you will know eventually, but next time when you ask them for members' information, they can't answer you. But still, you can only rely on their notice. And every year, when you ask for members' information, when you do inspection, only then will you realize the change, right? Thank you, Chairman. Later on, I'll ask Mr. Lee to supplement. Every year, REO will contact the constituent organizations to ask them to update their member list. Then at that moment, we can see what updating needs to be done. Mr. Lee? As Ms. Chung said, every year we will check with constituent organizations on the members list. So they will produce registered members list, and then we will cross-check with our voters' information. We'll see whether anyone has lost eligibility, and then we will make inquiries. We do the same work every year. Okay. If there is no more question, then it's about time. I would like to seek your views, members. Now, many questions have been asked today. Please give us written reply to members' questions. Our next meeting will be on the 9th of June. After the hearing, we will continue to discuss. Before that, do we need one more meeting for discussion? Or after the public hearing, we can make further arrangement? Originally, I do not intend to have a meeting before that. Today, you have raised the points that you are concerned about. Mr. Ho, Ms. Ho, Chairman, I think we should listen to views first. Actually, the text is factual. So we will either agree or disagree. So I think we won't argue on the details. We will just differ as to whether we agree or disagree. Okay, we will ask our secretary to check the time. Okay, then that means after the 9th of June. If that's the case, then let's move on to AOB. There is no AOB. So on the 9th of June, we will have a public hearing. So far, 2 deputations had indicated their interest to attend. If there are other organizations that may be interested, please let them know. So meeting is adjourned here. Thank you very much.